This is the American Law Journal.
Well, when you use social media, you think of sharing photos and stories with your friends. What you may not know is that lawyers and private investigators may be mining your Facebook, Twitter, and other accounts to find that smoking gun evidence to win their divorce or custody case. Good evening, I'm Christopher Naughton. Welcome to the American Law Journal. This week, divorce, custody, family law matters, and how they intersect with social media. Don Spry joins us this evening from King Spry, Herman, Freund, and Fall. Over 30 years in practice for Don. He has taken cases to the very highest courts in his state. Joseph Gill steps up to the plate for the very first time, at least on this program. He's a private investigator, and he is the principal in the investigative firm of Gill and Associates in Philadelphia, Pennsylvania. And Thomas Snyder joins us for the very first time tonight, a partner with Einhorn Harris, Asher, Barbarito, and Frost. It's New Jersey's largest family law practice. And Tom just argued a case before the New Jersey Supreme Court. I'm sure we'll get to that tonight. Well, going back 20 or 30 years ago, Don, you didn't have to worry about Facebook. But I bet you the first time a client steps into your office, that's maybe the very first thing you're chatting with them about.
In the old days, you would say never write anything that you don't want to come out in court. Mm-hmm. So it's the same with Facebook, email, because it does. So
Tom, if you don't mind hearing something on the 6 o'clock news about yourself, go ahead and write it on Facebook. But if you're concerned about that, don't.
I'll do you one better. Shut it off, unplug it, get it out of the house.
Do you actually tell them that?
I don't tell them because that's not necessarily practical. But I will tell you this, right in my retainer agreement, I caution people about using social network regarding Facebook, things of that nature. What you're posting there may come back to haunt you in ways that you cannot even imagine. Mm-hmm. So the truth is, use it for business, use it for the standard stuff that you need. But listen, when it comes to posting pictures of you down in the Bahamas with who it may be, you don't want that in there.
And I agree wholeheartedly with Tom and Don just said. And when I bring a client in, I like to look at their Facebook page. And the reason I do that is some people think that the more friends that they have, the more popular that they are. And usually clients that have an exorbitant number of friends are very vulnerable to having their Facebook page hacked by somebody maybe we don't want them to watch.
Conversely, I'm sure that lawyers, the first thing they also do after they tell their clients, get off of Facebook or watch what you write, the very next thing they're doing is they're sending their clerks, their assistants, maybe their secretaries out to look at the Facebook page and social media of their adversary.
Absolutely. And what people don't realize is that Facebook changes daily. So instead of it somebody looking at it on a one-shot deal and putting it away, they have to continue to be reminded to make sure they keep their guard up and their privacy up. Because what happens is if you don't tell them, in the course of leaving your office, they'll remember for a day or a week or a month, but then without some kind of reminding mechanism, a couple months down the road, they've forgotten about it and they're back to their old habits that only hurt them.
And Don, there's only so many things that you can tell a client. For example, you can't tell a client, go into your spouse's Facebook page or maybe into some of the private data. There are certain guidelines that you must tell your client if he or she is going to do some excavating and mining for themselves.
Well, yeah, I mean, you have to be careful. We were talking earlier, for example, going into a computer. I mean, if your spouse has their own password for the computer, then you can't do that. If it's a family computer, you can. But, examples of this are all over the place. I've had situations that are kind of common is, typically when people are getting divorced, they separate and it may be a couple of years before they get divorced. So they move on. And in support court, for example, if you're the person that's paying, you want to convince the court that you're not earning a lot of money. But when you get on, a dating site, you want to tell about how much you're making.
I can't believe you brought that up because, we talked a little bit earlier. Maybe I'm jumping ahead, but it's exactly the case I had. I was trying a case. Guy wasn't paying his child support. I went in. We had a hearing whether or not he had the ability to pay. I pulled out his Match.com website listing, and he puts in there he makes 150 plus. I put all my proofs in. I was sitting on that one document thinking, should I put it in? Should I not put it in? Heck, I put it in. I put it in. Judge renders a decision, and the decision, you better believe the judge referred to that, and it impacted it. Might not have carried the day, but definitely set the tone, set the flavor, and let the judge know who we were dealing with.
And sometimes the information that is imparted on Facebook may not in and of itself be germane. However, it might lend itself to an argument of credibility. I think, Don, you've spoken about on this program where, one of the exes says, oh, I'm not dating anyone at all. And then later on, a private investigator or through Facebook, you find out, the guy is kissing a woman in the park. somewhere.
Well, yeah, I was
and
mentioning-
that's not a crime, but lying is,
well,
so to speak.
The irony of that was it was a custody case, and the mom said she wasn't seeing anybody, not having any relationship, and the private investigator had a video of her, kissing in the park and all of that. The irony of that is it wouldn't have been an issue in the custody case. It became an issue because her credibility was shot. And in domestic relations cases, as we all know, it's a lot of he said, she said. Mm-hmm. So if you don't have credibility in a domestic relations case, you have a problem.
So what about emails and texting with an ex-spouse? And that's a dual...
Texting. I think of Tiger Wood when I think texting. The text heard around the world.
Right.
Listen, texting is awesome. It's great for lawyers. We were talking, you used to be a prosecutor. In today's world, they put it all in print. It's great. It's just, you get someone on the stand and you can cross-examine them, or did you say this, did you say that? And they, amazing what you get in testimony these days by virtue of texting. But the thing that people forget sometimes, when you're getting that text and you respond, sometimes people forget that their response is coming in front of a judge as well. And often they shoot themselves in the foot, literally, well, figuratively, when it comes to representation, credibility, and who's the good guy and who's the bad guy.
And Joe, again, that's a sword that cuts both ways, because now, you've got a record and that works, unless, of course, it's your client that got emotional or provocative with their text.
What always happens is that my clients seem to have a short memory. But when you ask them the question, was there any texting, they're thinking short term, no pun intended. Mm-hmm. What happens is they forgot over the months of involvement here the texts that have been going out. And if the attorney or the private investigator knows the extent of the texting and the contents of those texting, we won't be caught blindside down the road where it's brought to our attention and then we look at our client and say, we asked you that question.
Attorneys and private investigators are going to use texting and social media for a lot of reasons. According to at least one study, they're going to use it to demonstrate the state of mind of one of the parties, evidence of communication, evidence of time and place, and evidence of actions. And I've got to think, Don, that it may also be evidence of emotion, because unlike maybe a business transaction that goes sour, emotion may not play a big part of contractual litigation. When we're talking family law, emotion is half the story. So if someone gets irate or someone cusses in a text or in an email or on social media, now all of a sudden they're a step or two behind.
There's a good and a bad about emails. I mean, the good side of it is sometimes when we are involved in custody cases, you can avoid he said, she said by saying to your client, only deal with the other parent by email. That's a good thing. But then and I think Joe was saying this, and Tom to some extent also, when those emails go back and forth and it starts to ratchet up, when that language that sometimes is in the emails gets into a courtroom in front of a judge, in that context, you almost feel like crawling under a table. I mean, it becomes embarrassing. The client looks terrible, and it's going to affect the judge.
If I could jump in just to follow up on that, we're talking about texting between two adults. There's certainly situations in custody matters where the child will text to their mother or their significant other that, my uncle just left the room. And that uncle in this particular case was the person responsible for supervised custody. Mm-hmm. So as a result, what would happen is the uncle and the father would pick the child up and drop the child off. But in between, during the time period when that uncle is supposed to be supervising in this supervised custody matter for only 4 hours, I might add, that uncle would leave to go grocery shopping, and with the aid of surveillance, through that innocent text, we were able to develop information to certainly help our client's case.
I mean, there's a case out of New Jersey, and I'll toss this to you, Tom, because this is front and center in your state, where attorneys actually told, I think, some of their secretaries, why don't you go into the Facebook accounts of our adversary in this particular case and befriend them, find out a little bit more about them. I think that matters before the New Jersey Supreme Court, if I'm not mistaken.
I'm not sure if it's in front of the court right now, and my recollection is it may actually be a disciplinary issue.
Okay.
But the truth of the matter is exactly that. Listen, you can't forget the RPCs when you're dealing with this type of technology. Just the RPC says you're not supposed to be having communications with the adverse client, going onto Facebook and friending them, and in that case, as I understand it, they actually used a fake name to friend the person, is quite candidly poor judgment at best and offensive, quite candidly. That's not the way we should be doing law, nor do we in New Jersey.
And Don, you could also be on a slippery slope if you know that your client's ex is a hothead. And if you just provoke him, you stick the badger in the eye a little bit, all of a sudden he's going to start reacting and give you the kind of legal gifts you're looking for. But you as an attorney can't have your client emotionally provoke the client. How do you deal with that gray area? Because it might be fertile for your case.
Yeah, well, a couple things. What Tom was mentioning about that ethical case, and I agree with that. You can't befriend fraudulently to get into that private information, but that's not necessarily the end of the ball game, because in Pennsylvania there's some case law that if the public part of Facebook suggests that there might be something in the private part of Facebook, you can ask for a court order for discovery, and you may get it. I mean, that's the proper way to do it. Court could always say there's not enough. It comes up in context where a personal injury case where the person on Facebook, on the public part of Facebook, said, well, I was out running today and whatever. That was enough in a case to get a court order to see what was in the private part of Facebook. Okay? So you can still get at it sometimes in the proper way.
And there's other proper ways as well. Some people forget to defriend people. Some people forget to defriend their spouse. And the spouse sits there and takes it all in. I had a case, woman was, she was down in New Orleans watching the NCAA double finals. She was out in California, wine country, sending pictures back while she was supposed to be home taking care of children. And, it was all on the husband's Facebook account. Nothing wrong with that. He was allowed to print it out and bring it to the judge and say, hey, look at what she's doing, Judge. And it was successful in terms of addressing that issue.
Joe Gill, you're going to say something.
I was, and I agree with what both my counterparts have said. Obviously, when a husband and wife split up, that doesn't mean their Facebook friends go with one or the other. And yes, most of the times his relatives will be defriended and hers will be defriended. But oftentimes what happens is there's somebody on his side that's able to gain access to her Facebook and vice versa. And the question becomes, and I know we talked, it's a slippery slope that we're talking about, but it is somebody who wasn't befriended, who didn't get on there just, using a suitable pretext. They have been a friend for years. They happen to be friends of both, maybe more friends, say, with my client. So what they'll do is they'll give us information, print it out, that's available for review as they continue to monitor on behalf of my client the adverse side's Facebook page.
Which goes back to the issue. Shut it off. Don't
Right.
post. Stay away from Facebook when you're going through a divorce or a custody case.
Well, can you use a GPS on your spouse or your ex-spouse's car? What about wiretapping or taping a phone conversation with that ex-spouse? And does taking photos by a private investigator of your spouse on the way to his next dalliance really count in a court of law? That and more when we come back on ALJ.
This week's American Law Journal has been made possible in part by King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Einhorn Harris, a long-standing community law firm with the largest family law practice in New Jersey. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
Be careful what you say on Facebook. It can and may very well be used against you in a divorce court of law. Good evening. I'm Christopher Naughton. Welcome back to the program. Three guests with me tonight as we discuss family law issues. Don Spry, in practice now for over 3 decades, although King Spry, Herman, Freund, and Fall, located throughout Pennsylvania, is indeed a general practice, personal injury, business, family law, and the like. Joe Gill joins us tonight, a private investigator, heads up his own firm in Philadelphia, Pennsylvania. Gill and Associates, the name of that firm, and he's been doing this, if I read the CV correctly, Joe, you've been in the business since 1978.
That is correct.
Okay.
That is correct.
That's
Your
good.
information is
So
accurate.
obviously this work keeps you young. And Thomas Snyder joins us for the very first time tonight, a partner with Einhorn Harris, Asher, Barbarito, and Frost. It's New Jersey's largest family law practice. So let me ask you both, Don and Tom, how often do you use a private investigator in a divorce and custody matter? Is it just every great once in a while? Do you find that you need to go to the well? Does that include the investigation of social media? Is that the primary usage, or is it the old, if I may use this term, Joe, the old gumshoe, the old gumshoe going out and taking photos of the ex or the soon-to-be ex having an affair?
I can't say that I use a private investigator a lot, and it's because of expense. A lot of clients don't have the money to do that, but I've used both the old gumshoe, which is the videoing of somebody, and the modern forensic computer type. And if the client has the money to do it and I want to get into computers, I will recommend a private investigator because the laws with respect to access, it's easy to be afoul of the criminal law when you're dealing with some of those issues. I mean, I know the basics, and I'm fine with that, but too many times a client will come in with what they think is great evidence against the other spouse, and it's something that can't be used. It was illegally obtained.
And sometimes, and we're going to get to that in a second.
Occasionally I'll use a PI. Okay. I supplement it.
But is money
money's a consideration
factor?
Often, you know, and you have to balance it. You know, you have to be cautious because judges aren't always thrilled with, you know, a spouse spending a lot of money on a PI when they're coming to court saying they need money for support. It's not always, you have to be tactful in terms of picking and choosing your battles relative to the information you're going to get from a PI. Certain limited situations, definitely. The case right now, you know, we're using a PI and it's going to be worth it ultimately given what's at stake. But other cases, you really have to be cost conscious sometimes.
And Joe, how often does that come up when adultery is one of 17 or 18 different reasons you can pursue divorce in New Jersey, Pennsylvania, or Delaware? I mean, it really doesn't have much probative value. It may help someone determine whether they're going to divorce the guy or not.
It does. And they talked about the surveillance aspect, and that's certainly something we do a lot of from a family court perspective. But again, there it's a situation, we talked about technology changing with the social networks, so has the equipment that investigators have used. It used to be that you had to be parked in front of the person's house to get a good videotape. Now, with the cameras that are available to us, specifically the lenses on those cameras, we could be a football field away and look at the wrinkles underneath that person's eyes. And you had mentioned about it not being it could be cost prohibitive, and that's 100% true. And one of the things that I recommend, and certainly we can't bait anyone, but if my client is going, and especially if they're in a cohabitation relationship where separation is inevitable, but it hasn't happened, if my client is going to go out of town for a weekend and possibly bring the kids, that might be the opportunity to retain a private investigator, because if he or she is ever going to hang themselves and do something, it's going to probably happen when they don't have to answer to anybody, especially for a weekend. And
if I jump in, Joe mentioned something, cohabitation. You see that in the context of alimony obligations, which are subject to termination on cohabitation or modification. And that's a perfect example where you really need someone, you know, out there verifying. Is the guy out there shoveling the sidewalk, raking the leaves, cleaning the gutter, comes there every night, and then once we say he lives there, he takes off for 6 weeks. So that's a great context where you see good use of a PI for sure.
Right, and if I could just jump in there to follow up on that point. And what happens with cohabitations, what we like to do is the night before, go there, 11 o'clock at night, mark the door, put a stone on the tire. I know that's old gum school technology, but at 5 o'clock the next morning, wait for him to leave. And once he leaves, surveillance is over. We're cost effective. We've only spent a couple hours. Maybe show some repetition over the course of a couple weeks that he's clearly living with this female at this address. And there's an example of surveillance that's cost effective and very time consuming.
Now, what I've seen in some court records recently is GPS tracking, and we know that the Supreme Court, even this very conservative Supreme Court, said that, for example, the government, police, cannot put a GPS tracking device on someone's car unless they get a warrant. But this is a little bit of the constitutional law tutelage that we offer our viewers. An individual is not the same as the government. So if you do want to put a GPS tracking device on someone's car, you generally can get away with it, can you not?
I think it depends. If you put the GPS device on a car that is titled in your client's name,
right,
and the spouse is driving it, that's fine. But if it's titled to the other spouse, it could be a problem. So
but what rules? But see, it's interesting, and I don't think there's any, certainly no specific legislative enactment that's going to give you guidance. But there's some case law.
Well, as I understand it, I read some article. I think Virginia may have a GPS statute, so state by state. But that's an example. I had a custody case where my client put a GPS on her son's vehicle, which is permissible because it's a child. But I think that's an example. If I was going to do that, I would probably hire a private investigator that knew the rules, because not only are you concerned about violating some statute, you want the evidence to come in. You know, you don't want the evidence excluded if you're going to do that.
You want to use it ultimately.
And I agree with Don. I don't put a GPS on anyone's car. I call Joe. The fact
But you're
is,
doing it on behalf of your client.
the reality is, you're right. Listen, here's my concern with GPS is you run the risk of a potential domestic violence complaint being filed against your client because it implies some type of observation and gives rise to a possible stalking claim.
Harassment, yeah.
You got to be cautious of that. You know, what's the purpose for which it's being used? Is it being put on, if the car is titled to the husband, he puts it on his car and the wife uses that car? Okay, that may be a legitimate purpose, may be consistent with statute. But then if he uses that information and it means to harass her, saying, you know, I know you were here, I know we were there, why aren't you home? I know where, you know, fill in the blank, and he's consistent with that. You know what? Even that legal conduct may be deemed domestic violence, stalking, restraining order, and he's potentially in New Jersey out of the house. Got to be cautious of that. It's a dangerous thing.
And another thing that clients have to be even more cautious of, because there's less of a gray area, if someone walks in your door, Don, and says, hey, I've got this cassette tape and my ex has just spilled the beans. Attorney Spry, listen to this.
Yeah.
What do you have to tell them right away?
It's a big problem because, this all goes on expectation of privacy. I mean, if somebody leaves a voicemail, you can use it.
Alec Baldwin.
Yep. My client comes in and says, I have this tape. He didn't know I was listening. I want to use this. I can't listen to it.
Right.
Number one, I can't listen to it ethically. It's illegal. So you can't use it. You have to tell them
It's worthless.
it's worthless.
Not only that,
and you can't
now
talk about it.
And Don and I talked about this. It becomes another problem because when the discovery demand comes into play, now you know this person has this tape. You have an obligation to make sure it gets turned over. Creates a whole series of problems. We talked a little bit before the show started. What happens when, Don, when the client sends you an email saying, hey, I have these emails from my husband and his lawyer. Look at all the stuff they're talking about. And they think they hit the jackpot, and you're like, oh, you know, we're not allowed to look at that. We have to, you know, there's action we have to take as lawyers to correct the problem, and that's not a good thing, clients. You know, it sounds wonderful in theory, but in practice, we got problems.
Joe, again, the government would need a warrant for a wiretap. What does an individual need to get or obtain first if they really do want to get someone on tape admitting some aspect of this divorce or custody matter?
Counsels have hit the nail on the head here. Whoever owns the car and is titled to the car, if it's in their name, they can put a GPS on it, even if their significant other's driving that.
Got it.
But let's not just limit ourselves to vehicles. Telephones, the same rules apply. By that I mean, if I have a plan and it's under my name and my husband, or in my case, my wife and my children's name are on it, if I wanted to activate their GPS on their phone, if it's under my name, just like the ownership of a car, I have the ability to turn a GPS unbeknownst to them and track them accordingly.
End of the story is that we live in an age where our expectation of privacy has been winnowed down further and further and further. How does that impact the courts when one party wants to gain access to a private Facebook account? They want to get access to telephone data. Do we find that those walls are crumbling and now it's actually easier to access this information, where maybe 5 or 6 years ago the wall would be a much more difficult threshold than it is today?
I think courts actually, I can only speak in Pennsylvania, I think courts do try to protect privacy, but the rules are just different because I think there's less of an expectation of privacy. And you know, I don't think judges are anxious to just let people willy-nilly get into other people's affairs. But the practicalities of it are, as Joe and Tom were talking about, you know, I mean, if you have a computer that's a family computer, it's open season. If it's password protected by one of the spouses, then you can't go in. So the rules are different. And as people, I think the law is just emerging in this area. I just think, and that's what Tom was talking about, I think it's just risky when you deal with this stuff because you don't know, you know, the cases have not settled on some of these things. And you just don't know where you're going to end up and what you don't want. I mean, you know, in domestic relations cases, everything's up in the air anyway. So to add this to it, at the end of the day, what you're trying to do is to get your client a fair settlement and get on with their lives. And while this can help you do that, it can also put huge roadblocks up.
Right, more headaches than it's worth, Tom.
Don, I agree completely, and I'll also suggest this, as the judicial population becomes younger and younger, they're becoming more computer savvy. So judges, who've grown up with computers now or have a better, I think, grasp of what's going on in terms of verifying, authenticating, and getting a sense of what's out there, what should be coming in. The one thing we haven't talked about is spoofing. There's this whole issue where people create fake email addresses, fake Facebook pages, and you run the prospect of something not being authentic. So there's a whole evidentiary complex issue to this. I think judges handle that appropriately. My experience is that they address it appropriately. They give it the context. In other words, I get an email at 3 in the morning, I'm going to come over and kill you. Well, and that's the only email, maybe someone questions that. But when you have an exchange of emails going back and forth, and it's in the context of the parties' issues, it gets more credibility, and more likely the judge is going to consider that. Listen, they'll let us go and try to authenticate that email, but that becomes a costly process as well. Trying to get stuff from web providers is somewhat challenging sometimes and costly.
And Joe will give you the last words tonight. Sum it up for us, sir, if you can.
Well, we talked about all the things that social networking does, and a lot of times it gives the impression that it's a negative, but more often than not, it is example after example of how it's a positive. And by that I mean, it from an investigative standpoint, it allows the investigator still another tool to try to solve whatever he's trying to accomplish, whether it be asset information, whether it be whether or not an individual is working, whether it be if they're seeing someone else possibly. And the more tools that an investigator can have, the easier it makes my job.
I'm going to add to that. Yeah, I agree, Joe. It's great. You know what? We see the truth. We see what people are really saying, not what they pretend to say when they get on the stand.
Exactly.
And there's no privileged information there, but you can go to our Facebook page, to our Twitter account. You can also check us out at lawjournaltv.com. Again, every week we tackle a different legal issue, dispensing legal advice on a week-to-week basis. I want to thank my guests tonight, Don Spry with King Spry, Herman, Freund, and Fall, family law practitioner of 3 decades plus, Joe Gill with Gill & Associates, private investigation firm in Philadelphia, Pennsylvania since 1978. Joe's been involved in the biz. And Thomas Snyder, partner with Einhorn Harris, a prominent family law practice in the state of New Jersey. Thanks for joining us this week, and until next week, case closed.
This week's American Law Journal has been made possible in part by King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Einhorn Harris, a long-standing community law firm with the largest family law practice in New Jersey. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.